Before we dive in, it is critical to understand that the information provided in this presentation is for general informational purposes only and does not constitute legal advice. This video is not a substitute for advice from a qualified attorney licensed in your state. Viewing this content does not create an attorney-client relationship. The law changes and varies significantly from state to state, and your specific circumstances can dramatically alter the outcome. Please consult with a competent legal professional for advice tailored to your individual situation. You think the hardest part of a divorce is the heartbreak, the screaming matches, the gut-wrenching moment you have to tell the kids. And you're not wrong, that's brutal. But the real soul-crushing part? The part that keeps you awake at 3 a.m. with your heart pounding? It's the unknown. It's the tidal wave of questions crashing over you, each one more terrifying than the last. Can he take my retirement? Will she get the house? Am I going to be financially ruined? What if I do something wrong and lose my kids? The fear isn't just about the end of a marriage. It's about the fear of making a catastrophic mistake in the fog of war. A mistake that could haunt you for the next 20 years. That's why we're here. We're cutting through the noise, the fear, and the bad advice from your well-meaning cousin. We have compiled the absolute most common, most critical, and most urgent questions people ask divorce attorneys in the United States, behind the soundproof doors of a consultation room. We're not going to give you vague "it depends" answers. We're going to give you the strategic framework, the red flags to watch for, and the foundational knowledge you need to turn that fear into a plan. By the end of this, you won't just have answers. You'll know the right questions to ask, how to protect yourself, and how to walk into this process with clarity and confidence instead of chaos and confusion. So let's get straight to it. The first question is almost always the same. Do I really need a lawyer? Can't we just be amicable and use a mediator? This is the foundational question, and the answer depends entirely on your definition of amicable. Let's be crystal clear on the roles. A lawyer is your advocate. Their job, their entire legal and ethical duty, is to protect your interests and get the best possible outcome for you. A mediator, on the other hand, is a neutral third party. They don't work for you. They don't work for your spouse. They work for the agreement. Their job is to help the two of you find a middle ground you can both live with. They cannot give legal advice to either of you. So, when can mediation work? It can be a fantastic, cost-effective tool if and only if certain conditions are met. First, there must be a relatively equal balance of power. If one of you has always controlled the finances and the other has been kept in the dark, that's not an equal balance. Second, there must be a foundation of trust and a commitment to full financial transparency. Both of you must be willing to put all your cards on the table, every bank account, every retirement fund, every debt. Third, both of you must have the emotional capacity to negotiate in good faith without being railroaded or intimidated. If your relationship was generally respectful, you have a solid grasp of your finances, and you can communicate effectively, mediation could be a great path. However, there are giant flashing red lights where you absolutely 100% need your own attorney from the start. If there is any history of domestic violence, coercion, or intimidation, mediation is not safe. If there are substance abuse or significant mental health issues at play, you need an advocate. If you suspect for 1 second that your spouse is hiding assets or being less than truthful about money, you need a lawyer who has the power to issue subpoenas and conduct formal discovery. If you have complex assets like a family business, restricted stock units, or multiple properties, you need an expert to ensure they are valued and divided correctly. Trying to mediate in these situations is like bringing a butter knife to a gunfight. You are setting yourself up for a disastrous outcome. Even in the best-case mediation scenario, you should always have your own independent attorney review the final settlement agreement before you sign a single thing. That document will control your financial life for years to come. Spending a few $100s to have an expert vet it is the best insurance you can buy. This leads directly into the next terrifying question. How much is all of this going to cost? The fear of financial ruin from legal fees alone is enough to keep people paralyzed in unhappy marriages. Let's demystify it. The vast majority of divorce attorneys work on an hourly basis and require an upfront payment called a retainer. A retainer is not a flat fee. It's more like a down payment or a security deposit for your legal fees. The attorney places it into a special trust account, and as they and their staff work on your case, making phone calls, drafting documents, appearing in court, they bill their time against that retainer. When the retainer runs low, you'll be asked to replenish it. So what determines the final price tag? It's not the lawyer, and it's not you. It's one word: conflict. Conflict is the engine that drives legal fees. The more you and your spouse argue, the more it costs. Every nasty email that requires a lawyer's response, every refusal to turn over a bank statement, every emergency motion filed over who gets the kids for a holiday weekend. That's all billable time. You could have $10 million in assets, but if you and your spouse agree on how to divide it, your divorce could be relatively inexpensive. Or you could have nothing but debt, but if you fight tooth and nail over who gets the chipped coffee mugs, your legal bills could skyrocket. The single biggest factor in the cost of your divorce is the behavior and reasonableness of the person on the other side. That said, you are not powerless. The way to keep costs down is with organization and strategy. Come to your lawyer prepared. Gather your financial documents ahead of time. Make a list of your questions before you call so you can be efficient. Respond to your lawyer's requests promptly. And most importantly, learn to choose your battles. Is it really worth paying your lawyer $500 to fight over a $200 piece of furniture? A good lawyer will help you do this cost-benefit analysis, guiding you on what is truly worth fighting for versus what you should strategically let go. Okay, so you're starting to see the landscape. That brings us to the most immediate, action-oriented question of all. I think a divorce is coming. Maybe not today, maybe not tomorrow, but it's on the horizon. What are the absolute first things I should do right now to prepare and protect myself? This is where you go from being a victim of circumstance to the CEO of your own life. First, and this is counterintuitive, stop talking and start gathering. Do not get into a heated argument and threaten divorce. Do not announce you're leaving. The moment you do that, the game changes. Information can disappear, passwords can be changed, and money can be moved. Before you signal your intentions, you need to become a financial detective in your own home. Your mission is to gather and make copies of at least the last 3 to 5 years of financial documents. We're talking tax returns, both personal and business, bank account statements, credit card statements, mortgage and home equity line of credit documents, car titles and loan information, statements for every retirement account for 401k, IRA, and pension, pay stubs for both you and your spouse. Make digital copies and upload them to a secure cloud drive that your spouse cannot access, or make physical copies and store them at a trusted friend's house or a new safe deposit box. This isn't about being sneaky. It's about preserving the status quo. This information is the bedrock of any divorce settlement, and having it up front prevents a long, expensive fight later trying to find what's been hidden. Second, schedule a consultation with a top-rated divorce attorney in your area. Even if you're not 100% sure you're going to file, a consultation is a confidential, fact-finding mission. It gives you a roadmap. You will learn the specific laws of your state regarding property division, alimony, and child custody. You'll get an expert opinion on the potential outcomes in your case. This single meeting can arm you with more valuable, actionable information than months of frantic late-night Googling. It turns the terrifying unknown into a set of known variables you can plan for. Third, and this is one of the most common and costly mistakes people make, do not, unless there is a threat of physical harm, move out of the marital home before speaking with an attorney. In many states, voluntarily leaving the residence can have serious negative consequences. It can be interpreted as abandoning the property, potentially weakening your claim to it. Even more critically, it can set a precedent for child custody that can be very difficult to undo later. A judge might see it as you leaving the children in the care of the other parent, establishing a status quo that the court will be reluctant to change. Your safety is always priority number one, but if you are not in physical danger, stay put until you have a legal strategy. Get a legal opinion before you pack a single bag. And a key part of that strategy is understanding the financial and temporal landscape you're about to enter. This brings us to the next giant, flashing question mark in every client's mind, a question often whispered with a sense of dread. How much is this going to cost me? Let's be brutally honest. Divorce is expensive. It's the financial equivalent of performing surgery on a living, breathing organism, your shared life. The goal is to separate the two of you with as little damage as possible, but there will be costs. The first number you'll likely hear from an attorney is the retainer. Think of this as a down payment for legal services. It's an upfront fee that your lawyer will bill their hourly rate against. In many parts of the country, a retainer can range from $3,000 to $10,000, and in high-asset or high-conflict cases, it can be significantly more. And once that retainer is used up, you'll have to replenish it. The single biggest factor that determines the cost of your divorce is not the value of your assets. It's not how many kids you have. It's conflict. Conflict is the gasoline poured on the fire of legal fees. I've seen couples with a modest home and 2 cars spend over $100,000 in legal fees because they chose to fight over every single thing. Every email, every phone call, every motion filed with the court is a transaction that costs money. You might spend $5,000 in legal fees arguing over a $500 television. The math is insane, but emotions make people do financially insane things. Your attorney's hourly rate could be anywhere from $200 to over $1,000 an hour. So is that angry 10-page email you're about to write to your spouse's lawyer, which your lawyer will have to read and respond to, really worth $1,000? Conversely, I've seen multimillionaires with complex businesses, multiple properties, and intricate investments settle their divorce for a fraction of that cost. Why? Because they chose to treat it like a business negotiation, not a war. They set their emotions aside, focused on a fair outcome, and worked together to find a solution. The secret to a less expensive divorce is to be organized, responsive, and reasonable. Gather your financial documents before you even see an attorney. Make a list of your assets and debts. The more work you do yourself, the less you have to pay a lawyer or their paralegal to do it for you. And remember, your lawyer is your legal advocate, not your therapist. While they can and should be empathetic, using an hour of their time to vent about your spouse's new partner is the most expensive therapy session you'll ever have. Save those conversations for a qualified mental health professional who is not only better equipped to help you process those emotions, but will also charge you a lot less. This brings us to the next question, which is inextricably linked to cost. How long is this going to take? If cost is the financial mountain, time is the emotional marathon. The answer, frustratingly, is it depends. An uncontested divorce where both parties agree on everything, and I mean everything from who gets the dog to how the retirement accounts are split, can be over in a matter of months. It's a straight shot down the highway. You file the paperwork, wait for your state's mandatory cooling-off period to pass, which can be anywhere from 30 days to over a year, and a judge signs off on your agreement. It's the best-case scenario. However, the moment one person contests one thing, you've exited the highway and are now on a winding country road with detours and traffic jams. A contested divorce can easily take a year, 2 years, or even longer. Why? Because the legal process has built-in steps that take time. First, there's the filing and service of the initial petition. Then the other party has a certain amount of time, usually about 30 days, to file a response. After that, we enter the discovery phase. This is where both sides exchange information. It involves formal requests for financial documents, written questions called interrogatories, and depositions, which are out-of-court testimonies under oath. This process alone can take months, especially if one party is being difficult, hiding assets, or dragging their feet. Once discovery is complete, you move into the negotiation phase. Your lawyers may exchange settlement proposals. You might attend mediation. If you can reach an agreement, your attorneys will draft a final settlement, and you're done. But if you can't agree, you start preparing for trial. This is where the timeline expands exponentially. Getting a trial date on a busy court's calendar can take 6 months to a year. And the trial itself is the final, most expensive, and most time-consuming part of the entire process. So, the length of your divorce is almost entirely within your and your spouse's control. The more you can agree on, the faster and cheaper it will be. The very idea of a trial, of course, raises the most fear-inducing question of all. Do I have to go to court? The word court conjures images from movies and TV shows. A sterile room, a stern-faced judge in a black robe, a witness stand where your deepest secrets are laid bare. It's a terrifying prospect. But here is the single most important, anxiety-reducing secret the legal dramas don't tell you. Over 95% of divorce cases in the United States settle before ever going to a trial. Let me repeat that. The overwhelming majority of people who get divorced never have a judge make the final decisions for their family. Just because you file for divorce with the court system, it does not mean you are destined for a courtroom battle. Filing is just the administrative start of the process. The real work happens outside the courtroom. Most cases are resolved through what's called alternative dispute resolution, or ADR. The most common form is mediation. In mediation, you and your spouse, with or without your attorneys, sit down with a neutral third party, the mediator, whose job is to help you find common ground and reach an agreement. The mediator doesn't make decisions for you. They facilitate a conversation. It's confidential, it's far less formal than court, and it allows you to craft a creative solution that works for your specific family. rather than having a one-size-fits-all solution imposed on you by a judge. Another great option is a process called collaborative divorce. In this model, you and your spouse each hire a specially trained collaborative attorney, and you all sign a contract agreeing that you will not go to court. If the process breaks down and someone decides to litigate, both attorneys have to withdraw. This creates a powerful incentive for everyone to stay at the table and work things out. The collaborative process often involves a team of professionals, like a neutral financial expert to help with the numbers and a family specialist or child psychologist to help create a parenting plan. It's a holistic approach designed to preserve relationships and solve problems constructively. The bottom line is this: you want to avoid going to trial if at all possible. A trial is a place of last resort. It is unpredictable, incredibly expensive, and emotionally devastating. You are handing the most important decisions of your life, about your children, your home, your financial future, over to a complete stranger who has maybe a few hours to learn about your entire life before making rulings that will affect you for years to come. You and your spouse, even in the midst of conflict, know your family better than any judge ever will. Settling your case through negotiation, mediation, or collaboration isn't a sign of weakness. It's a sign of strength. It's you taking control of your own destiny. And taking control of your destiny almost always starts with taking control of your finances. This brings us to the question that's probably been screaming in the back of your mind since the moment the word divorce was first uttered. It's the elephant in every consultation room, the number one source of anxiety for so many people. The question is simple, but the answer is complex. How much is this all going to cost? If you go online, you'll see articles throwing around average costs, $10,000, $15,000, even upwards of $25,000 per person. And let me tell you, those numbers can be paralyzing. They can make you feel like you're trapped, like you can't afford to leave an unhealthy situation. But here's the most important thing I can tell you about the cost of a divorce. There is no price tag. There is no menu. The cost of a divorce is not a number. It's a direct reflection of one thing and one thing only: conflict. The single biggest expense in almost every divorce is the attorney. So let's pull back the curtain and talk about how lawyers actually charge you, because understanding this is your first step to controlling the cost. When you hire a divorce attorney, you'll typically be asked for a retainer. This is one of the most misunderstood concepts in law. A retainer is not a flat fee for your entire divorce. It is not the total price. Think of it like a down payment or like loading money onto a Starbucks card. You give your lawyer, say, $5,000. That money goes into a special trust account. As your lawyer and their staff work on your case, they track their time. At the end of the month, they deduct their earned fees from that trust account and send you a bill showing you exactly what they did and how much money is left on your gift card. When the money runs out, you have to replenish the retainer. And how do they track that time? Almost always it's by the hour. A lawyer's time is their inventory, and they bill in small increments, usually 1/10 or 2/10 of an hour. That means a 6-minute or a 12-minute minimum. So that quick 3-minute phone call to ask a simple question, you just got billed for 6 minutes. That email you sent, the lawyer bills for the time it takes to read it, think about it, and draft a response. A flurry of 5 separate emails in a day can easily add up to an hour of your lawyer's time. If your lawyer's rate is $400 an hour, you just spent $400 of your retainer on a handful of emails. This is where the control comes back to you. I want to tell you about 2 cases I handled. They were remarkably similar on paper. Both couples had been married about 15 years, had 2 kids, a house with a mortgage, and similar incomes. From a legal standpoint, they were almost identical, but their final bills were worlds apart. Let's call the first couple the fighters. From day one, everything was a battle. He accused her of hiding money. She accused him of being a bad parent. They couldn't agree on who should get the $50 coffee maker. Their emails to me were long, emotional, and frequent, often multiple times a day, detailing every single perceived slight from the other spouse. They used their lawyers as weapons, and as a sounding board for their anger and grief. Every step required a formal motion, a court hearing, and hours of back and forth between the attorneys. Their divorce took 2 years, and their combined legal fees were over $100,000. They bled themselves dry fighting over the scraps. Now let's talk about the second couple, the planners. They were just as sad and hurt as the fighters. The end of their marriage was painful, but they made a crucial decision early on. They decided to treat the divorce like the dissolution of a business partnership. They were civil. They agreed to disagree on some things, but they kept their focus on the big picture, the kids and their financial future. They communicated with their lawyers efficiently. They would save up their non-urgent questions and send one organized email per week. They went to mediation, sat in a room with a neutral third party, and hammered out a deal on their own terms. Their divorce was finalized in 7 months. Their combined legal fees were less than $15,000. What was the difference? It wasn't the law. It wasn't the assets. It was the conflict. The fighters paid their lawyers to fight. The planners paid their lawyers to facilitate a solution. You are the single biggest variable in your own legal bill. Every time you pick up the phone to vent, every time you fire off an angry email, you are making a financial decision. You are literally turning your anger into someone else's billable hours. But attorney's fees are only part of the story. There are other, hidden costs that can quickly add up. You have court filing fees, which are usually a few $100s. You might need to pay a process server to formally deliver documents to your spouse. But the real budget busters are the experts. If you and your spouse can't agree on the value of your house, you'll need to hire a real estate appraiser. That's a cost. If you own a business, you might need a business valuation expert, which can cost thousands or even tens of thousands of dollars. If one of you suspects the other is hiding assets or misrepresenting their income, you may need a forensic accountant to dig through financial records. This is incredibly detailed, time-consuming work, and it is very expensive. And the most emotionally and financially draining expert of all, the custody evaluator. If you and your spouse cannot agree on a parenting plan, a court might appoint a psychologist or a social worker to conduct a full-blown investigation into your family. They will interview you, your children, teachers, and doctors. They will conduct psychological testing. They will write a detailed report recommending a custody arrangement to the judge. These evaluations can cost anywhere from $5,000 to over $25,000, and they are an invasive, stressful, and heartbreaking process for everyone involved. Hiring a custody evaluator is like dropping a bomb in the middle of your divorce. Sometimes it's necessary, but it should always be a last resort. So, how do you keep these costs from spiraling out of control? You get strategic. First, get organized. Before you even meet with a lawyer, start gathering your financial documents. Tax returns, pay stubs, bank statements, credit card statements, mortgage documents. The more organized you are, the less time your lawyer or their paralegal has to spend doing it for you at hundreds of dollars per hour. Don't show up with a shoebox full of crumpled receipts. Second, communicate efficiently. As we saw with the planners, use email wisely. Keep your communication concise and fact-based. If you need emotional support, and you absolutely will, talk to a therapist, a friend, or a family member. Your lawyer is your legal strategist, not your counselor. Using them as a therapist is the most expensive therapy you will ever find. Third, and this is the hardest one, you have to pick your battles. You have to constantly ask yourself, is this fight worth the cost? Fighting over that $1,000 painting is going to cost you $2,000 in legal fees. It makes no sense. You have to separate the emotional value of an item from its monetary value. Let go of the small stuff. Focus on what truly matters. Your kids, your long-term financial security, and your sanity. The bottom line is this. While you can't control your spouse's behavior, you can control your own. You can choose to be a fighter or a planner. You can choose to fan the flames of conflict or to seek resolution. The cost of your divorce, more than anything else, will be a reflection of those choices. It's a bitter pill to swallow, but understanding this gives you power. It puts the control over your checkbook and your future right back where it belongs, in your hands. But we all know that the most valuable asset, the one that holds all the memories and represents stability, isn't something you can easily put a price on. It's your home. And the question that keeps people staring at the ceiling at 3 in the morning, the one filled with fear and uncertainty, is, do I have to be the one to move out? We're going to unpack that emotional minefield next. So let's get right to it. The short answer is no. No, you do not have to move out of your house just because your spouse tells you to. Let me say that again because it's one of the most important things you'll hear. You do not have to pack a bag and leave the marital home simply because you're getting a divorce and your spouse wants you gone. Legally, as long as it's the marital residence, the home you shared during the marriage, you both have an equal right to be there. It doesn't matter if your name is the only one on the deed or the lease. It doesn't matter if your spouse was the one who paid the mortgage every month. In the eyes of the court, until a judge says otherwise, that home is a shared asset, and you have just as much right to be under its roof as they do. Your spouse cannot legally change the locks. They cannot throw your belongings out on the front lawn. They cannot call the police and have you removed for trespassing. You are not a guest. You are a resident. But, as with everything in divorce, the simple legal answer is rarely the complete one. While your spouse can't just kick you out on a whim, a judge absolutely can. This is done through something called a temporary order, or more specifically, an order for exclusive occupancy. Some people call it a kick-out order, and it is exactly as serious as it sounds. A judge will not issue one of these lightly. They understand that removing someone from their home is an extreme measure. To get a judge to sign off on an order like this, your spouse has to prove that your presence in the home is causing tangible, demonstrable harm. We're not talking about awkward silences at the dinner table or passive-aggressive notes left on the refrigerator. We are talking about serious situations. The number one reason a judge will grant a kick-out order is domestic violence. If there is credible evidence of physical abuse, threats of violence, or a pattern of harassment and intimidation that puts the other spouse or the children in fear for their safety, the court will act swiftly and decisively to create a safe environment. This is a protective measure. The court's primary job is to prevent harm, and if that means one person has to leave the home, so be it. But the definition of harm is broader than just physical violence. The other major reason a judge will order someone to leave is to protect the children from an excessively toxic or high-conflict environment. Think about it from the judge's perspective. Their guiding principle, their North Star in every decision, is the best interest of the child. If your home has become a war zone with constant screaming matches, if the tension is so thick you could cut it with a knife, and the children are being emotionally damaged by the crossfire, a judge might decide that the only way to protect them is to separate the combatants. One of you will be ordered to leave to give those children a chance at peace and stability, even while the divorce is ongoing. Now, a crucial point here is evidence. You can't just walk into court and say, "My spouse is crazy, make them leave." Doesn't work that way. You need proof. This could be police reports, photos of injuries, threatening text messages or emails, or testimony from witnesses who have seen the conflict firsthand. This is also why the dark side of this issue exists: false allegations. It is a grim reality that sometimes, in a desperate attempt to gain leverage, one person will fabricate or exaggerate claims of abuse to get the other person kicked out of the house. Courts are very aware of this tactic. If you are falsely accused, it is absolutely critical to fight it with every tool you have, because not only could you lose your home, but it could devastate your chances at custody down the line. So legally, you have a right to stay unless a judge orders you out. But that brings us to the much more complicated strategic question: should you stay? Just because you can stay, does that mean you should? This is where the legal answer and the right life answer can diverge dramatically. Let's talk about the strategy. For many attorneys, the default advice is often, do not move out of the house. Whatever you do, stay put. And there are some powerful strategic reasons for this. First, possession is 9/10 of the law. By staying in the home, you maintain control over the property. Second, and this is the big one, it helps establish what we call the status quo for child custody. If you are the parent who stays in the family home with the children, going to school from there, sleeping in their own beds, you are creating a routine. When it comes time for a judge to make a temporary custody decision, they are often very reluctant to disrupt a stable routine for the children. The parent who has already established themselves as the primary caregiver in the family home has a significant advantage. Moving out can be perceived, rightly or wrongly, as ceding that ground. Furthermore, moving out is expensive. You're suddenly on the hook for rent, a security deposit, and utility bills for a new place, all while you're likely still expected to contribute to the mortgage on the marital home. Financially, staying can feel like the only viable option. But let's be honest. Living in the same house with the person you are divorcing can be a unique form of psychological torture. Can be a living hell. Every interaction is strained. You're walking on eggshells, sleeping in separate rooms, dividing up refrigerator space, and communicating through gritted teeth. The emotional cost of that environment can be devastating. It can drain you of the energy you need to negotiate your divorce, to be a good parent, and to simply function. And what about the children? Yes, staying might look good for the status quo on paper, but what is the quality of that status quo? Is it better for them to have both parents under one roof if that roof is constantly shaking from the force of your arguments? Or would they be better off in a calmer, more predictable environment, even if it means splitting their time between two homes? Sometimes the most courageous and responsible act of co-parenting you can do is to be the one who leaves, to intentionally de-escalate the conflict for the sake of your kids' well-being. This is where we need to bust a huge myth. Many people are terrified to move out because they believe they will be charged with abandonment. They think if they walk out that door, they are abandoning their rights to the house and their rights to their children. Let me be clear. In the context of a divorce, this is almost entirely false. Legal abandonment is a very specific term. It means you leave with no intention of ever coming back, you stop paying for anything, and you cease all contact with your children. Simply moving into a nearby apartment to escape a toxic living situation while your divorce is pending is not abandonment. You are not forfeiting your claim to the equity in the home. You are not forfeiting your right to be a parent. If you do decide that moving out is the best choice for your sanity and for your children, you just have to do it smartly. You communicate your intentions in writing to your spouse and your lawyer. You state clearly that this is a temporary measure to reduce conflict, and that you fully intend to pursue your equitable share of the home's value and a fair custody schedule. You take your personal belongings, and you set up a parenting plan immediately. Done this way, moving out isn't an act of surrender. It's a strategic move for peace. Ultimately, the decision of whether to stay or go is one of the first, and most difficult, crossroads you'll face in a divorce. There is no one-size-fits-all answer. It's a gut-wrenching calculation of legal strategy, financial reality, and your own emotional endurance. It's about weighing the tactical advantage of staying against the human cost of the conflict. But whether you stay or you go, one thing is certain. The bills don't stop. The mortgage, the utilities, the groceries. Who pays for all of it while the divorce is dragging on? And more importantly, if you were the spouse who stayed home or earned less, who pays you? That brings us to one of the most misunderstood and explosive topics in all of divorce law: alimony. Is it a guarantee, a myth, or a weapon? We're about to find out. The truth is, it can be all three. Alimony, or what many states now call spousal support or maintenance, is one of the most emotionally charged and legally complex parts of any divorce. It's born from a simple idea: that marriage is an economic partnership. If that partnership dissolves, one partner shouldn't be left financially destitute, especially if they sacrifice their own career or earning potential for the good of the family. It's not a punishment for the person paying, and it's not a lottery win for the person receiving it. Think of it less as a permanent pension and more as a financial bridge. Its purpose is to get a lower-earning spouse from the financial dependency of marriage to the shore of self-sufficiency. But the length and strength of that bridge depend entirely on the facts of your specific case. And this is where the myths start to crumble. The first and biggest myth is that alimony is automatic. It is absolutely not. I've seen countless people walk into a consultation assuming that because their spouse earned more, they are guaranteed a check every month. In reality, it's one of the most discretionary decisions a judge makes. Unlike other areas of divorce that can be formulaic, alimony is often a judgment call, a delicate balancing act based on a whole host of factors. The second myth is that it's just for women. That's a black and white snapshot from a 1950s sitcom. The law is entirely gender neutral. It's about the roles played in the marriage, not the gender of the person playing them. If a husband was a stay-at-home dad for 15 years while his wife built a massive tech company, he is the one with a potential alimony claim. The only things the court cares about are need and ability to pay, who needs support and who has the ability to provide it. That's the entire game. But the myth that causes the most fear and confusion is that alimony lasts forever. While this can happen, it is exceedingly rare in the modern legal landscape. It's a relic of a time when very long-term, single-earner households were the norm. Today, there are several different types of alimony, and most of them have a built-in expiration date. The most common type is called rehabilitative alimony. This is the financial bridge I was talking about. It's designed for a specific purpose and a limited time. Let's say a wife left her nursing career a decade ago to raise the kids. The court isn't going to just give her a check for life. Instead, they might award her rehabilitative alimony for, say, 2 years. That money is intended to give her the means to get her nursing license recertified, take some refresher courses, and support herself while she re-enters the workforce. The goal isn't dependency, it's independence. Then you have temporary alimony, which is exactly what it sounds like. It's support paid while the divorce is still pending, to make sure the lower-earning spouse can pay the bills and keep the lights on until the final orders are in place. There's also reimbursement alimony, which is less common but fascinating. This is for situations where one spouse financially supported the other through a long, expensive degree, like medical school or law school, with the shared expectation of a lucrative future. If they divorce right after the degree is finished, but before they get to enjoy the financial fruits of that labor, the court might order the newly minted doctor or lawyer to essentially pay back the investment their spouse made in their education. And finally, yes, there is permanent alimony, sometimes called lifetime support. This is the one everyone talks about, but it's the unicorn of the divorce world. To even be in the running for permanent alimony, you're typically looking at a very long-term marriage. We're talking 20, 25, 30 years or more. And even then, it's usually reserved for cases where one spouse is at or near retirement age, or has a significant health issue or disability that makes it unrealistic for them to ever become fully self-supporting. For the vast majority of divorcing couples, the idea of a lifelong alimony check is pure fiction. So, if it's not automatic and it's usually not permanent, how on earth do judges decide who gets it, for how long, and for how much? There is no magic calculator. Instead, they weigh a list of factors that vary slightly from state to state, but the core ingredients are almost always the same. The single biggest factor, without a doubt, is the duration of the marriage. A 5-year marriage where both spouses work? The chance of alimony is slim to none. A 25-year marriage with a massive income disparity? Now you're in the heart of alimony territory. Next, they look at the financial need of the person asking for support and the other person's ability to pay. It's a simple question. Can the requesting spouse support themselves in a lifestyle reasonably comparable to the one they had during the marriage? And if not, does the other spouse have enough income after paying their own expenses to help bridge that gap? They also consider age and health. A healthy 35-year-old who can easily re-enter the workforce is in a very different position than a 60-year-old with chronic health problems. The court also looks at the contributions each person made to the marriage. This is critical. It's where the law formally recognizes that the value of a stay-at-home parent who managed the household, raised the children, and enabled the other spouse to focus on their career is a massive economic contribution, even if it didn't come with a paycheck. And now for the bombshell factor that can turn a case on its head. Marital misconduct. In many states, the concept of fault is still alive and well when it comes to alimony. This means that if you committed adultery, for example, it could potentially reduce the amount of alimony you receive, or in some states, bar you from receiving it altogether. This is why an affair can be more than just a personal betrayal. It can be a catastrophic financial mistake. Proving that fault, however, is its own brutal, evidence-intensive battle. This is where alimony can transform from a legal concept into a weapon. Because it's so discretionary, it becomes a major point of leverage in negotiations. One spouse might threaten a long, ugly court battle over alimony to force the other into settling for less on property division. A higher-earning spouse might suddenly quit their high-paying job or take a massive pay cut, a tactic attorneys call vocational suicide, hoping to argue they no longer have the ability to pay. Courts are wise to this, and they have the power to impute income, meaning they can calculate alimony based on what that person should be earning, not what they've suddenly decided to earn to dodge their obligation. The fight can get nasty, with private investigators, vocational experts, and forensic accountants all being brought in to argue over what someone is capable of earning versus what they are actually earning. So we've covered how the law tries to balance the financial scales for the spouses. But what about the kids? When it comes to child support, the judge's discretion often takes a back seat to something far more rigid and powerful, the cold, hard math of state-mandated guidelines. And the numbers might shock you. You see, nearly every state in the US has adopted a set of child support guidelines. Think of it not as a suggestion, but as a rigid mathematical formula. A calculator. The judge plugs in the numbers, and the calculator spits out an answer. The reason for this is consistency. The system is designed to ensure that a child in one courtroom gets roughly the same level of support as a child in a similar financial situation in the courtroom next door. It's meant to take the guesswork, the personal bias, and the emotional drama out of the equation, and instead focus on one thing: the child's right to benefit from the financial resources of both parents, as if they were still living together. The most common formula, used in the vast majority of states, is called the income shares model. It sounds complicated, but the logic is actually pretty simple. First, the court looks at both parents' gross monthly incomes. That's your income before taxes and any other deductions. Let's say parent A earns $6,000 a month and parent B earns $4,000 a month. The court adds those together to get a combined parental income of $10,000 a month. This number represents the total family pot of money that would have been available to support the children if the family had remained intact. Next, the court consults a state-specific chart. This chart is the heart of the calculation. It's a massive table created by economists that estimates how much a family at that specific income level, in our case $10,000 a month, would typically spend on their children. Let's say for a family with 2 kids, the chart says that family would spend $2,500 a month on the children for basic needs like housing, food, clothing, and transportation. This $2,500 is called the basic child support obligation. Now, the court figures out each parent's percentage of the combined income. Parent A earns $6,000 out of the $10,000 total, so they are responsible for 60% of that basic obligation. Parent B earns $4,000, so they are responsible for 40%. This means Parent A's share is $1,500, and Parent B's share is $1,000. Finally, the model assumes that the parent the children live with most of the time, the custodial parent, is already spending their share directly on the kids every day. So the other parent, the non-custodial parent, pays their share to the custodial parent. If Parent B is the custodial parent, Parent A would pay Parent B $1,500 per month in child support. It's a transfer of funds to ensure the child's household has the full $2,500 the state deems necessary. But this immediately raises one of the most fought-over questions in all of divorce law. What exactly counts as income? People think it's just their salary, but the court's definition is incredibly broad. It's not just your W-2 wages. It's your bonuses, your commissions, overtime pay if you work it consistently. It's the income from your side hustle driving for Uber on the weekends. It's rental income from that property you own. It's investment dividends, pensions, social security benefits, and even unemployment benefits. The court is looking for every single stream of cash flow. And this is where things get really contentious. What happens if a parent tries to game the system? What if, for example, a high-earning surgeon, knowing a divorce is coming, suddenly quits his lucrative practice to go work at a coffee shop for minimum wage, claiming he had a change of heart and wants a simpler life? He then goes to court and says, "Your Honor, I can't pay much child support. I only make $2,000 a month." The court has a powerful tool for this exact scenario. It's called imputing income. The judge can essentially say, "I don't believe you. You are voluntarily underemployed." The court will look at that surgeon's education, their work history, their skills, and what they could be earning if they were working to their full potential. The judge can then decide to calculate child support based not on the surgeon's current barista salary, but on the $30,000 a month they should be earning. The court literally imputes that income to them and orders them to pay support as if they were still a practicing surgeon. This prevents parents from deliberately tanking their income to shirk their responsibility to their children. Now, that basic child support calculation, the $2,500 in our example, is meant to cover the essentials: a roof over their head, food in the fridge, clothes on their back. But as any parent knows, kids cost a lot more than that. So, who pays for everything else? Who pays for the health insurance premium? What about the $500 copay when your son breaks his arm at soccer practice? Or the $4,000 for braces? These are called add-on expenses, and they are handled separately, on top of the base child support amount. The two most common add-ons are the cost of health insurance for the child and any work-related childcare expenses. The court will take the total monthly cost for these items, and just like with the basic support, divide it between the parents based on their proportional shares of income. So if childcare is $1,000 a month, Parent A in our example would be responsible for 60%, or $600, and Parent B for 40%, or $400. The same goes for unreimbursed medical expenses. The first $250 per year is often one parent's responsibility, but after that, big-ticket items like dental work, therapy, or prescriptions are typically split proportionally. But then you get into a gray area. What about the non-essentials? Who pays for private school tuition? What about the travel hockey league that costs $10,000 a year? Or summer camp? Or a car for a 16-year-old? These are called discretionary or extraordinary expenses. There is no automatic rule for these. A judge will look at the family's standard of living before the divorce. If the kids have always gone to private school and the parents can still afford it, a judge is very likely to order them to continue paying for it. But if it's a new expense, it becomes a matter of negotiation and argument. And that brings us to the biggest extraordinary expense of all, college. This is one of the most common and shocking misconceptions people have. In the overwhelming majority of states, a parent's legal obligation to pay child support ends when the child turns 18 or graduates from high school, whichever comes later. Your divorce decree does not automatically obligate your ex-spouse to pay for a single dollar of college tuition, room, or board. If you want your ex to be legally required to contribute to college costs, it must be explicitly written into your marital settlement agreement. Some states do allow a judge to order parents to contribute to college, but it's not the norm. For millions of families, this becomes a major point of conflict years after the divorce is final. Finally, there's one more giant variable that dramatically changes the child support calculation: parenting time. The classic formula I described assumes one parent has the child most of the time, and the other parent has them, say, every other weekend. But what happens in a 50-50 custody arrangement, where the child spends equal time in both homes? In that case, the paying parent often gets a significant credit or reduction in their child support payment. The logic is that if you have the child half the time, you are already spending a significant amount of money directly on their needs. You're buying groceries, paying for a larger home, covering their daily expenses. The formulas get much more complex, taking into account the exact percentage of overnight visits each parent has over the course of a year. This is why, unfortunately, some of the most bitter custody battles aren't just about time with the child. They are fought over percentages and overnight stays, because every single night can shift the child support calculation, sometimes by hundreds of dollars a month. So the numbers are set, the checks are written. But money is just one half of the equation. The other half is far more precious, and far more contentious: time. Who gets the kids on Christmas morning? Who decides which school they attend? And what happens when one parent wants to move 3 states away? That's where we enter the brutal, emotional world of child custody. When people walk into my office to talk about custody, they're not just talking about a legal strategy. They're talking about their identity. They're talking about the fear of missing their child's first day of school, the terror of not being there to tuck them in at night. It's a primal fear. And the legal system, in its cold, structured way, has to translate that raw emotion into a court order. To do that, it first breaks down the very idea of custody into 2 distinct parts, and understanding this difference is the single most important first step you can take. First, there's legal custody. Think of this as the big picture decision-making power. Who decides if your child gets braces? Who chooses their doctor or therapist? What school district will they be in? What religion, if any, will they be raised in? In the vast majority of cases across the United States, courts will award joint legal custody. This means both parents have an equal say in these major decisions. The court wants both parents to be involved. It forces you to co-parent, to communicate, and to work together for your child's future, even if you can't stand to be in the same room. Sole legal custody, where one parent makes all the decisions, is rare. It's typically only granted in extreme situations, like a proven history of severe abuse, neglect, or a parent's total abandonment of the child. The second part, and the one that causes the most conflict, is physical custody. This is exactly what it sounds like, where the child physically lives. This is about the day-to-day schedule. Who helps with homework on a Tuesday night? Who makes breakfast on a Saturday morning? This can also be joint or sole. But here the word joint can be misleading. Joint physical custody doesn't automatically mean a perfect 50-50 split. It could be a 60-40th split, a week-on/week-off schedule, or any number of arrangements where both parents have significant, frequent time with the child. The parent with whom the child spends slightly more time is often called the primary physical custodian, while the other is the non-primary or secondary custodian. This distinction becomes incredibly important when we talk about child support later on. So this brings us to the million-dollar question every single parent asks. How does a judge, a total stranger who has maybe spent a few hours on your case, decide this? How do they decide who gets the kids? The answer is guided by 3 words that you will hear over and over again. The best interests of the child. That phrase is the North Star of every family court in every state. It's not about what's fair to the parents. It's not about punishing one parent or rewarding the other. It is a singular, focused evaluation of what environment will allow the child to thrive. But what does that actually mean? It's not just a vague feeling. It's a checklist of factors a judge is legally required to consider. They'll look at the stability of each parent's home, not who has the bigger house or more money, but who can provide a safe, consistent, and nurturing environment. They'll examine the child's relationship with each parent. Who has historically been the primary caregiver? Who took the child to doctor's appointments, attended parent-teacher conferences, and coached the Little League team. The court values maintaining the status quo if it's been a healthy one. The physical and mental health of the parents is also on the table. A parent struggling with an unmanaged mental health condition or a substance abuse problem is going to face an uphill battle in proving they can provide a stable home. And yes, a history of domestic violence is a massive red flag. A parent who has been abusive to their spouse is often seen as a risk to the child, even if the abuse was never directed at the child themselves. One of the most powerful and often overlooked factors is which parent is more likely to foster a positive relationship between the child and the other parent. Let me say that again. The court actively looks for the parent who will encourage phone calls, who won't badmouth the other parent in front of the child, and who will facilitate a healthy, loving bond with their ex. If you go into court with a scorched earth strategy, determined to prove your ex is a monster and should never see the kids again, it can backfire spectacularly. The judge might see you as the one creating conflict, the one unwilling to co-parent, and that can seriously damage your case. This leads to the next big question. Okay, I get it, but we're both good parents, so we'll automatically get a 50-50 schedule, right? Not necessarily. While equal parenting time is becoming more popular and even the legal presumption in some states, it is far from a guarantee. The best interest standard still reigns supreme. A judge will ask, is a 50-50 schedule actually practical and beneficial for this specific child? If the parents live 45 minutes apart, a week-on/week off schedule could mean the child has an unbearable commute to school every other week. That's not in their best interest. If the parents have a high-conflict relationship and can barely speak without screaming, a 50-50 arrangement with frequent handoffs could expose the child to constant stress and anxiety. Also not in their best interest. For a very young child like an infant who is breastfeeding, a 50-50 split might be developmentally inappropriate. The court's goal is to create a schedule that provides predictability and stability for the child, not one that satisfies a parent's desire for mathematical equality. Now for a question that comes loaded with a lot of anger and hurt. My spouse cheated on me. They destroyed our family. Surely that will affect who gets custody, right? This is a tough pill to swallow for many, but in most cases the answer is no. The court sees marital misconduct and parenting ability as two separate things. An affair, no matter how morally wrong or emotionally devastating, doesn't automatically make someone a bad parent. The judge's only question is, did that behavior negatively impact the child? If the affair was kept private and the child was shielded from it, the court will likely consider it irrelevant to the custody decision. However, it becomes very relevant if the cheating parent's behavior did harm the child. For example, if they left a young child home alone to meet their new partner, if they introduced the child to a revolving door of new friends, or if their actions exposed the child to arguments and emotional turmoil. It's not the act of infidelity the court punishes, it's the resulting impact on the child's well-being. Finally, there's the question that comes from the child themselves. My 14-year-old says she wants to live with me. Can she decide? The short answer is, a child's preference is a factor, but it is almost never the deciding factor. The weight a judge gives to the child's opinion increases with their age and maturity. A 7-year-old saying they want to live with dad because he has a new video game console will be given very little weight. A thoughtful, articulate 16-year-old explaining why they feel their emotional and educational needs are better met at mom's house will be taken very seriously. But even then, a judge will be cautious. They know that children can be easily influenced. They'll want to understand the reason for the preference. Is it because one parent has looser rules and no curfew? Or is it rooted in a genuine desire for stability and a stronger connection? Courts are very reluctant to put a child in the position of choosing between their parents, as it can create immense guilt and loyalty conflicts. Sometimes, a judge will speak with the child privately in their chambers, or a custody evaluator will be appointed to interview the family and make a recommendation. All of these factors, all of these decisions, are eventually hammered out and formalized into a document called a parenting plan. This is the rulebook for your post-divorce co-parenting life. It details the specific schedule for weekdays, weekends, and those all-important holidays. It outlines who makes the final call on medical or educational decisions if you can't agree. It sets rules for travel, for communication, and for how you'll resolve future disputes. This document is a court order. It's not a suggestion. Navigating custody is about shifting your perspective from the end of a marriage to the beginning of a new, restructured family. It's not about winning a battle against your ex. It's about creating a stable, loving foundation for your children as they grow up across two different homes. But of course, raising children requires more than just time and love. It requires resources. And that brings us to the single most fought-over financial topic in any divorce: child support. Who pays, how much do they pay, and where does all that money actually go? Let's start by dismantling the biggest myth about child support right away. It is not a prize for one parent or a punishment for the other. It's not alimony. It's not a penalty for the divorce. Child support is a legal and moral obligation, rooted in the simple, undeniable principle that both parents are financially responsible for their children. The court's entire focus is to ensure that the child's standard of living doesn't dramatically suffer because their parents chose to live apart. It's about providing for the child in two homes as closely as possible to the way they were provided for in one. So who pays? In the vast majority of cases, the non-custodial parent pays the custodial parent. Now, those terms can be a little misleading, especially as more and more parents move towards 50-50 custody schedules. A better way to think about it is this: the parent with a higher income, or the parent with less overnight parenting time, typically pays the other. Why? Because the law presumes that the parent who has the child more often is already spending their share of money directly on the child during that time. The child support payment is meant to balance the financial scales. But what about that 50-50 scenario? This is one of the most common questions I get. We have the kids exactly half the time. Why should I have to pay anything? The answer almost always comes down to income disparity. Let's imagine a couple, Mark and Jessica. They have two kids and agree to a perfect 50-50 custody schedule, week on, week off. Mark is an engineer and earns $150,000 a year. Jessica is a teacher and earns $60,000 a year. Even with 50-50 custody, Mark will almost certainly be ordered to pay Jessica child support. This isn't to give Jessica extra spending money. It's for the kids. The court wants to prevent a Disneyland dad or Marriott mom scenario. They don't want the kids living in a large house with every video game console one week, and then in a small apartment where the budget is tight for groceries the next week. That kind of financial whiplash is not good for a child's sense of stability and security. The child support from Mark to Jessica helps ensure that the children's experience, the quality of their food, their clothes, the home they live in, the activities they can participate in, is reasonably consistent and stable, no matter whose week it is. It equalizes the children's experience across both households. Now for the million-dollar question. How much? This is where things get complicated because there is no single national answer. Every single state has its own formula, its own calculator, its own set of rules. Anyone who tells you it's just a simple percentage of your income is giving you dangerously incomplete information. However, while the specific formulas vary, the ingredients that go into them are remarkably similar across the country. Think of it like baking a cake. Every state has a slightly different recipe, but they all use the same basic ingredients: flour, sugar, eggs. The main ingredients for the child support cake are the parents' incomes and the amount of time each parent spends with the child. First, income. This is the big one. The court will look at each parent's gross income from all sources. That's not just your salary. It's bonuses, commissions, self-employment earnings, rental income, even stock dividends. And here's a crucial point for anyone thinking of getting clever. Courts have very little patience for a parent who suddenly decides to quit their high-paying job to become a part-time dog walker right before a support hearing. If a court believes a parent is voluntarily unemployed or underemployed to avoid their child support obligation, they can do something called imputing income. They will calculate child support based on what that parent should be earning, based on their work history, education, and the job market in their area. I once saw a surgeon who claimed he had a change of heart and wanted to work at a coffee shop. The judge wasn't impressed and based his child support on his surgeon's salary, leaving him with an order he simply couldn't afford on a barista's wage. The lesson: the court's primary duty is to the child, not to a parent's sudden career change. The second key ingredient is parenting time, specifically the number of overnights the child spends with each parent per year. The more overnights a parent has, the more credit they typically get in the support calculation, which can lower the amount they have to pay. This makes sense. The more you have the child, the more you're spending directly on them. This is why custody battles and child support battles are so often intertwined. The parenting schedule directly impacts the financial outcome. Beyond those two main ingredients, the court will add in other required costs. These are often called add-ons. Who pays for the child's health insurance premium? That cost is almost always factored into the calculation. What about out-of-pocket medical expenses, like copays for doctor visits, dental fillings, or new glasses? The formula will specify how those costs are divided, often proportionally based on the parents' incomes. And the big one for younger kids, childcare. If a parent needs to pay for daycare or after-school care in order to work, that massive expense is added into the formula and shared between the parents. Things like private school tuition or expensive extracurriculars can also be included, but that often requires a specific agreement or a court finding that it's in the child's best interest and affordable for the parents. So the state provides the recipe, you provide the ingredients, your incomes, your parenting schedule, your add-on costs, and the calculator spits out a number. That number is the presumptive child support amount. It is considered legally correct unless one of you can prove a very good reason to deviate from it. Finally, we arrive at the most emotionally charged question of all. Where does the money actually go? The paying parent often feels like they're writing a check directly to their ex for their personal use. They see their ex go on a vacation or buy a new car and think, "That's my child support money." This is by far the most common and destructive misconception. Let me be crystal clear. The receiving parent has absolutely no legal obligation to provide an accounting or a set of receipts for how they spend child support. The law presumes they are using it for the benefit of the child. And the reality is they are. Child support is designed to cover both direct and indirect costs. Direct costs are the obvious ones: food in the refrigerator, shoes on their feet, the copay at the doctor, school supplies, a birthday present. But the indirect costs are where the real money goes, and what so many people fail to understand. Child support pays for the child's share of the roof over their head. It pays a portion of the mortgage or the rent. It pays a portion of the electricity bill that keeps their lights on, the water bill for their baths, and the internet bill for their homework. It pays a portion of the car payment, insurance, and gas for the vehicle that gets them to school and soccer practice. Think of it this way. If the custodial parent lives in a home with 2 children, it's reasonable to assume that 1/3 of every single household bill is attributable to each child. A $1,000 rent payment? Over $300 of that is for one child's shelter. A $200 electric bill? Nearly $70 of that is for their lights, their television, their video games. When you add up the child's share of all these fixed household costs, you quickly realize that the child support payment often doesn't even cover these basic shelter expenses, let alone all the direct costs. The receiving parent is still paying the lion's share of the costs of raising that child out of their own pocket. Child support is not a windfall. It's a contribution. It's a way for the non-custodial parent to fulfill their responsibility to a household they no longer live in, but their child does. It ensures that the lights stay on, the heat stays on, and there is a safe and stable home for the child. Understanding these 3 components, who pays, how it's calculated, and where it goes, is critical. It can help shift the perspective from a fight between exes to a shared investment in a child's well-being. But that leads to 2 more urgent, practical questions that every client asks. What happens if they just stop paying? And on the flip side, what happens if my income changes or their income changes? Can this number ever be changed? Let's tackle the first fear head-on. What happens if they just stop paying? This is, without a doubt, one of the most terrifying prospects for a parent relying on that support. You have a court order, a legally binding document signed by a judge, that says you are owed a certain amount of money on a certain schedule for your child. And then nothing. The payment date comes and goes, and your bank account is empty. The panic sets in. How will you pay for groceries? For the field trip? For the copay at the doctor's office? The first thing to know is this: the law is overwhelmingly on your side. A child support order is not a suggestion. It is a command. And the legal system has a vast and powerful arsenal of tools to enforce that command. This isn't a simple debt like a credit card bill. This is an obligation to a child. And the courts take that more seriously than almost any other financial duty. So what do? First, document everything. Every missed payment, every partial payment. Keep a clear running log. If you communicate with your ex about the missed payment, do it in writing, a text, or an email. "Hi, just checking in. The child support payment for this month hasn't come through yet. Is there an issue?" This creates a paper trail that shows you tried to resolve it amicably before escalating. If the payments don't resume, you go back to the court. You file what's typically called a motion for contempt. This is a formal legal document where you tell the judge, "Your Honor, you issued an order, and the other party is willfully disobeying it." The word willfully is key. The court wants to know if they can't pay or if they won't pay. If the judge agrees that the non-payment is willful, a whole world of consequences opens up. This is where the enforcement mechanisms kick in, and they can be incredibly effective. The most common and direct tool is an income withholding order, also known as wage garnishment. Your attorney or the state child support agency sends the court order directly to the non-paying parent's employer. From that point on, the child support is taken directly out of their paycheck before they even see it, just like taxes. It's automatically deposited into your account. This is the single most effective method because it removes the other parent from the equation. They no longer have the choice to pay or not to pay. But what if they're self-employed, or work for cash, or quit their job to avoid garnishment? The system has answers for that too. The court can authorize a bank levy. This means the state can go directly into their bank accounts, checking, savings, whatever they can find, and seize the funds to cover the past due support, which is called arrears. They can intercept tax refunds. This is a big one. The federal government and state governments work together. If your ex is owed a $5,000 tax refund but owes you $6,000 in back child support, they're not getting that refund. It's coming directly to you to cover what you're owed. They can place liens on property. This means if the non-paying parent owns a house, a car, a boat, or a piece of land, a legal claim is attached to it. They cannot sell or refinance that property without paying off the child support debt first. And then there are the motivators, the consequences designed to make life so inconvenient that paying becomes the easiest option. In most states, the court can order the suspension of licenses. And I don't just mean their driver's license, though that's a huge one. Imagine not being able to legally drive to work. We're also talking about professional licenses. Are they a doctor, a lawyer, a contractor, a real estate agent, a barber? They can lose the license they need to do their job. Even recreational licenses, like hunting and fishing licenses, can be suspended. Gets even more serious. If the arrears exceed a certain amount, federally it's $2,500, the U.S. State Department can deny their passport application or revoke their current passport. They will not be able to travel internationally until they pay what they owe. Their non-payment can be reported to credit bureaus, destroying their credit score and making it nearly impossible to get a loan for a car or a house. And the ultimate consequence, jail time. This is the last resort, reserved for cases of repeated, willful, and flagrant violation of the court's order. A judge doesn't want to put someone in jail because they can't earn money there. But if a person has the ability to pay and simply refuses, a judge can sentence them to jail for contempt of court until they either pay a portion of what's owed or agree to a payment plan. It's the legal system's final powerful statement that this obligation cannot be ignored. So, if you are the parent owed support, you have an army of legal tools at your disposal. The road can be frustrating, but it is a road with a destination. Now let's flip the coin. This leads directly to the second question. Can this number ever be changed? What if you're the one paying support and you lose your job? Or what if the parent receiving support gets a huge promotion and now makes more than you do? Is that original number set in stone forever? The answer is no. The law recognizes that life is not static. Things change. The legal term for changing a court order is modification. And you can petition the court to modify a child support order, but you need a very specific reason. The standard in most states is a substantial and continuing change in circumstances. Let's break that down. Substantial means it has to be a big enough change to make a real difference in the child support calculation. Getting a $1 an hour raise probably isn't enough. Getting a promotion that increases your salary by 30%? That's substantial. Losing your job and being unemployed for months? That's substantial. Continuing means it can't be a temporary blip. If you're a salesperson and have one bad commission month, that's not a continuing change. If your entire industry collapses and you're forced into a lower-paying career, that is a continuing change. So what kind of changes qualify? The most common is a change in either parent's income. If the paying parent suffers an involuntary job loss or a significant pay cut, they can ask the court to lower their support obligation. Notice the word involuntary. You cannot quit your six-figure job to go work for minimum wage just to lower your child support. The court will see right through that. In that case, a judge is likely to impute income to you, meaning they'll calculate the child support based on what you should be earning, not what you're actually earning. Conversely, if the paying parent gets a huge raise or wins the lottery, the receiving parent can ask for an upward modification, arguing the child should benefit from that newfound good fortune. The same is true if the receiving parent's income changes dramatically, either up or down. Another major reason for modification is a change in parenting time. Let's say the original order had the kids with one parent 80% of the time. But over the years the schedule evolves and now it's a true 50-50 split. The parent paying support can argue that since they are now covering the costs for the child half the time, the support amount should be recalculated and likely reduced. Changes in the child's needs can also trigger a modification. If a child develops a serious medical condition that requires expensive treatments and therapies not covered by insurance, the support amount may need to be increased to cover those new costs. The same goes for new educational needs like specialized tutoring. The most important rule here is that you cannot change the amount yourself. If you're the paying parent and you lose your job, you can't just decide to start paying half of the ordered amount. Until a judge signs a new order, the old order is in full force. Any amount you don't pay under the old order is racking up as arrears, that legally enforceable debt we just talked about, even if you have a good reason for not paying. You must go back to court and get the order officially modified. Getting these financial orders right, and knowing how to enforce or change them is critical. Because once these are set, they become part of the final, binding document that officially ends the marriage, the divorce decree. But what exactly is in that final decree? And what happens if someone violates other parts of it, not just the money? That's the final piece of the puzzle we need to solve. So, what's in this powerful document? This final judgment, this divorce decree? Think of it less as an ending and more as a detailed instruction manual for the rest of your life. Co-authored by you, your ex, and a judge. It's the rule book. And at its core, it officially declares that the marriage is over. You are legally single again. But that's just the first sentence. The rest of the book is where things get really specific. It contains a meticulous breakdown of property. Who gets the house? If it's being sold, what's the timeline, who's the realtor, and how are the profits split down to the last penny? Who gets the 2022 Honda Pilot, and who gets the 2018 Ford F-150? Who is responsible for the loan on each? It will list bank accounts, retirement accounts, investment portfolios, and explicitly state how they are to be divided. It might even get as granular as who gets the Peloton, the season tickets, or custody of the golden retriever. Every significant asset you acquire during the marriage is accounted for and assigned. And the same goes for debt. The decree will state, with no ambiguity, who is responsible for the remaining mortgage payments, who must pay off the $20,000 credit card balance, and who is on the hook for that home equity line of credit. This is critical because if your name is still on a debt, and your ex is ordered to pay it but doesn't, creditors can still come after you. The decree gives you the legal power to go back to court and force your ex to reimburse you. But it doesn't magically erase your name from the original loan document. If there's spousal support or alimony, the decree will spell it out in painstaking detail. The exact amount, the payment due date each month, how it's to be paid, and most importantly, the duration. Is it for 5 years? 10 years? Is it permanent? Does it terminate if the receiving spouse remarries or cohabitates with a new partner? The rules are all there, in black and white. But for parents, the most vital and often longest section of the decree is the parenting plan. This is the constitution for your co-parenting relationship. It establishes legal custody, who gets to make the major decisions about the children's health, education, and religious upbringing. It defines physical custody, where the children will primarily reside. And it lays out a highly specific parenting time schedule. It will say something like, the father shall have parenting time every first, third, and fifth weekend of the month from Friday after school until Sunday at 6 p.m. It will detail the holiday schedule for the next decade. Who gets Thanksgiving in even years, who gets Christmas in odd years. It will divide up spring break, summer vacation, and the children's birthdays. The goal is to leave nothing to interpretation, to minimize future conflict by creating a clear, predictable routine. And of course, it sets the child support amount based on state guidelines, again specifying who pays how much and when. It will also dictate who is responsible for maintaining health insurance for the children, and how uninsured medical expenses will be split. So you have this document, this incredibly detailed court-ordered rulebook for your new life. But what happens when someone decides to just tear out a page? What happens when your ex treats this binding court order like a suggestion? This is where we get into one of the most frustrating, yet powerful aspects of family law: contempt of court. When someone willfully violates a court order, like a divorce decree, the other party can file a motion for contempt. You're essentially going back to the judge and saying, Your Honor, you issued an order, and this person is ignoring it. I need your help to enforce it. We often think about this in financial terms. He's not paying child support. She's not paying her half of the credit card debt. And for those, the remedies are robust. Courts can garnish wages, intercept tax refunds, suspend driver's licenses, and even put liens on property. But what about the non-financial violations? What about the parts of the decree that govern behavior and cooperation? This is where life gets messy. Let's imagine your decree says you and your ex have joint legal custody, and all major decisions must be made together. One day, you discover your ex has unilaterally decided to pull your child out of their public school and enroll them in a private school across town, an expense you never agreed to and can't afford. That is a direct violation of the decree. Or consider the parenting schedule. The order says your ex is supposed to return the kids every Sunday at 6 p.m. But for the last 3 months, they've been showing up at 8, 9, even 10 p.m. The kids are exhausted for school on Monday, your Sunday evening is ruined, and your ex just shrugs and says, "Sorry, traffic was bad." This isn't just rude. It's a pattern of violating a court order. Let's take it a step further. Your decree has a standard clause that says neither parent will disparage the other in front of the children. But you start hearing from your 10-year-old that, "Daddy says you're the reason we can't afford a nice vacation." Or "Mommy says you don't work hard enough." This isn't just hurtful. It's a form of parental alienation and a clear violation of the court's order designed to protect your children from conflict. So what do? You don't just have to take it. The first step is to document everything. Meticulously. Keep a journal. Note every date, every time, every specific violation. Save every text message, every email where your ex is non-compliant. If they say in a text, "I'm not bringing him back at 6, we're at the movies," save it. That is evidence of a willful violation. They knew the rule and chose to break it. Once you have a clear pattern of violations, your attorney can file a motion for contempt. You both will have to go back to court for a hearing. Your ex will have a chance to explain their side of the story. They might say, "It was an emergency," or "I misunderstood the order." But if you have a logbook showing they were late 17 times in 6 months, traffic stops being a credible excuse. And this is the final crucial piece of the puzzle. What can a judge actually do? What are the consequences? They are significant. First, the judge can simply order the person to comply. A stern lecture from a person in a black robe can be surprisingly effective. Second, the judge can provide a direct remedy. For all that missed parenting time, the judge can order make-up time. You might get the next 2 holiday weekends to make up for the time you lost. For the unapproved private school tuition, the judge can order that your ex is solely responsible for 100% of that cost. Third, and this is a big one, the judge can order the violating party to pay your attorney's fees. The logic is simple. You would not have had to spend thousands of dollars on a lawyer and miss a day of work to come to court if your ex had simply followed the order in the first place. This makes them think twice before violating it again. Fourth, for repeated and serious violations involving the children, a judge has the power to modify the custody order. If a parent consistently demonstrates that they cannot or will not follow the parenting plan and co-parent effectively, the judge might decide it's in the child's best interest to change the arrangement, perhaps even giving the compliant parent sole decision-making authority. And finally, in the most extreme and defiant cases of non-compliance, a judge can impose fines or even jail time. It is rare, but the power is there. A divorce decree is not a piece of paper you can ignore. It is a direct order from the court, and defying it carries consequences that can impact your wallet, your time with your children, and ultimately, your freedom. Your divorce decree isn't just the document that ends your marriage. It's the blueprint for your new beginning. Knowing what's in it, and more importantly, knowing that you have the power to enforce it, is the key to closing that chapter and moving forward with security, stability, and peace of mind. It's the final tool you need to not just survive a divorce, but to build a new and successful life on the other side.